going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. I've got a spicy one. In this case, I'm just going to flat out say it. The attorney's in trouble. The defendant's in trouble. I guess, I don't know if it's really a defendant when it's a divorce case. I think it's a child custody underlying case. There's a lot going on here. This is apparently third or fourth time they've been in court. And yeah, mom's just not following the court orders, and her attorney is kind of letting it happen. So they're both in trouble. Well, let's watch how it goes down. Before I hit that play button, you know what to do. Hit the like and subscribe to your Jump Kick Backflips. Let's go.
File number 23-7584-DM, time and date set for show cause hearing. Parties are present, appearing on behalf of the plaintiff is Attorney Amanda Rogenbug. Appearing on behalf of the defendant via Zoom is Attorney Jamal Harris. Before we proceed in this matter, I didn't preside over the last matter. It was, I believe, it was the Honorable Judge Borchard. And my understanding that all counsel and all parties were to appear in person. I wasn't at the proceeding. What's going on here at this time? First, Ms. Roger.
Thank you, Judge. Actually, Judge Borchard deferred the hearing to today because he saw the size of the file and complexity and advised all attorneys and all parties were to be present at all proceedings going forward in person. And I think he mentioned that if there wasn't compliance, there would be some swift consequences for that. Prior to the last hearing that Mr. Harris appeared on, they didn't want to come. They called the court and said they didn't want to come. They wanted to appear by Zoom. They showed up. I spoke to Mr. Harris yesterday and I said, "You're coming, right?" "No, I don't plan on coming." I said, "You're required to be there." After that, they called your office and indicated that there was no contested hearing and they weren't going to be coming and they were going to appear by Zoom. This is the tenor of this entire case, Judge. We're told to do something. My client and I follow the rules. The defendant and her attorney, the rules don't benefit them. They just don't apply. This is why I have 4 5-inch binders of paperwork. They do nothing. They don't follow the orders. They don't follow the rules, and they don't follow the laws. And then my client has to pay the consequence for that. We were directed to be here in person. We're here in person. This is the 3rd hearing on this matter because the defendant has refused to comply with 2 lawful subpoenas. She's in default for the 2nd time in this matter. Frankly, part of my argument is going to be they don't have an opportunity to testify today or offer evidence. They're in default. They've never filed to change that default. But this is the tenor of the case. The defendant and her counsel don't follow the rules if it doesn't benefit them.
Harris?
May I respond? Okay, the prior judge, I never appeared before. I wasn't aware of that order. We did talk yesterday. So I did have our legal secretary called and she told me that we could appear by Zoom. It was a mistake because I guess our legal secretary wasn't aware of the prior judge's order. And I guess on the court's part that, for this matter, it was different, that every appearance has to be in person. But unfortunately, some confusion occurred and I was told that I could appear by Zoom. So of course, I did talk to Amanda yesterday. We talked about several things, but we wanted to make sure with the court that was correct. And the court said that, and I guess mistakenly so, that we could appear by Zoom. Our intentions were not to, get out of appearing in person. It was just that because of scheduling conflicts, that it would have been easier for me to appear by Zoom. The senior attorney here, he's been having health issues, and Jacob Perron is no longer with our office.
Right, I recall it because we met in person. I remember all meeting in person just outside of Chambers.
Yes.
Ms. Rogenbug, yourself, and I.
Yes.
And then obviously Judge Borchard had the hearing afterward, but even if you weren't here at the last hearing.
I was here at the last hearing.
Okay, so Judge Borchard made that statement, right?
No, I went in front of you last hearing.
Judge, if I can add some clarity.
Oh, okay, let's hear from Ms. Rogenbach.
Judge Borchard made that ruling on the 26th of July at a hearing.
Oh, okay.
And continued this. Opposing counsel was at the prior hearing with you when we also had the conversation that he had to be at these in person because they weren't going to come to the most recent hearing we had where they withdrew their objection. And I said, you have to be there, Judge. So their office knows. And the problem is, it's always a mistake, or they lost the mail, or they can't find the email, or they can't find the file, or their client didn't. There's always a reason that they don't have to comply. But those reasons don't apply to my client and I. If we didn't feel like coming today, I didn't call the clerk and go, well, my secretary called and there was confusion on our part. There has to come a point where there are consequences for the defendant and her attorney not to comply. My client has spent thousands of dollars to get records he should have had 6 months ago. They've never filed an objection to any of the subpoenas. Every time we get to the day before a hearing, oh, we're going to get them. And yet here we sit.
Do you have them?
No, Judge, we've received a portion of them.
Okay. Mr. Harris?
All right. You can see the frustration on the on this attorney's side. I got to stop saying defendant because I don't know. What is it? Is it someone who files it and then respondent? Isn't that what it works in a divorce? Anyways, yeah, lots going on here. The mom side has a lot to answer for, and partly the attorney's fault, it sounds.
Go ahead. You can supplement that.
Okay. We were trying to comply with the judge orders. We're trying to, as Amanda would tell you, we want to work this out and bring this to resolution. We're not trying to drag this on more than it needs to be. I cannot speak towards the previous counsel that was on this matter because, for reasons such as this, he's no longer with the firm. I'm trying to put out some of the fires that were started, not by me. So let's just make that clear that it wasn't me not complying. We did get some of the medical records. We had to use a password to get in. We didn't have that, unfortunately, until late yesterday. So
Judge, I'm
trying to, can I talk, counsel, please?
Excuse me, Mr. Harris, there was an objection. I'm just talking about, all I'm talking about at this point is the lack of appearing in court. That's what I'm asking about.
Okay. So
we can get Harris here in just a bit, but if Judge Borchard stated that, matter of fact, I just talked to him on an unrelated matter yesterday. But I mean, if the judge previously, that judge is the same judge that I have to follow him, he follows me. If you need to be here, you need to be here.
Okay, well, I wasn't trying to rebel against this order or anything such as that. Sometimes with our scheduling with attorneys and stuff like that, we have several matters on a particular day. So we asked maybe if we could appear by Zoom. We did the right thing. We went to the court, asked. We weren't told that we cannot appear by Zoom. So that's why I'm appearing by Zoom. No other reason than that. And I truly apologize, Your Honor, for not being there. I wish I could be there because I would have liked to talk to Amanda in person so that we can try to resolve this. And I think that's that's why we're here, is to resolve this. And we do want to get all the records to counselor, but I'm sorry, I'm trying as hard as I can. I have to do what I'm told. I do work for somebody, and and I guess it was just confusing, and we pray for the mercy and of this court that it was just an honest mistake. It wasn't intentional for us not being.
I'll address it as we move forward in the show cause.
Okay.
Ms. Rogenbach, what do you want to say regarding the show cause?
I'm prepared to make my argument, Judge. The preliminary item I would like to address is they're in default for the second time. I don't believe they have a right to present witnesses or evidence. Frankly, I don't believe they have a right to argue, but I will leave that to the court's deference, but I'm prepared to move forward.
Mr. Harris, you ready to proceed?
Yes, Your Honor.
Ms. Rogenbach, go ahead.
Judge, I'm going to lay out a brief timeline since this is a pretty lengthy case. On February 8th, the defendant received the first subpoena On February 29th, council was reminded of that subpoena in court. On March 15th, council was reminded of the first subpoena by letter to his office. On April 10th, the council received a correspondence regarding the subpoena. On April 11th, council actually responded and made no reference to the subpoena, but addressed everything else in the prior correspondence. On April 25th, council sent a letter to my office saying they had never received the first subpoena, but that they would provide records for the second subpoena. I want the court to know there's never been any objections to either subpoena filed. We came to court on June 7th. The court entered an order to compel for the February 8th and March or April 10th subpoenas. Council was to provide all records within 7 days. I will advise the court also that that date, council stated on the record, they had all the records in their office. They just had to go through them. There were
And I was at the hearing.
You were, Chairman. You
I
presided
recall
over it.
this.
You requested that my office submit an affidavit with our costs, which we did. That was also served on all the parties. There was never any objection. The requests for costs from that hearing are still outstanding with this court by affidavit. My office on 7/19 received a stack of documents, which we disclosed to the court when we were in court last time, that had page numbers cut off, information blurred out, sideways pages, upside down pages, backwards pages, so you could see shadows but not read it. Nothing could be organized. There are pages that just don't go to anything. Couldn't tell who they belong to. Then last night, my office, after 5 p.m., when I was gone for the day, fortunately I got to leave early, received 3 emails from opposing counsel with some additional records. But here's what we don't have yet. We don't have the mental health treatment records that have been subpoenaed for a multitude of months. We don't have the prescription records. We don't have the invoices or proof of payment. We don't have all of the specialist records. And we received no records from Ms. Hornbacher and her attorney about all the places she shopped this child around to. The reason that we had to file a second subpoena, Judge, was Ms. Hornbacher asked my client to pay a medical bill for a doctor she took the child to, refused to submit it to insurance because she didn't want it to know about it, but then asked him to pay half the cost because it was over $1,000. She was taking the child to different doctors, trying to get them to say the child was molested. Didn't work. We've never received those records. And as the court may remember from the June hearing, Mr. Ferrone said, we'll just subpoena all the doctors. There's no possible way that I can subpoena every doctor in the state of Michigan to find out if and when they saw this child. Ms. Hornbacher had this child in her exclusive possession for a period of time and was desperately trying to paint my client as a child abuser. We don't know where she took her and all the appointments. I know from looking at the records we have retrieved, there's reference in the notes to her taking the child to other doctors. We don't know who they are. There's no way for us to subpoena or to subpoena all those doctors, which is why we filed the subpoenas. To date, I do have the child's dental records. As I said, I have no mental health treatment for mom or for the child, with the exception that last night I did receive mom's second psychological from the school. Her prior or current employer required her to have a psychological, and we have received that. We have not received anything else regarding mother's mental health treatment. The court needs to be aware that it's a unique case. In 20 plus years, I've never had a case where the other side has done quite literally nothing, all the way back to the beginning. There's never been an answer filed. We agreed to set aside the first default. We entered a second default because we couldn't move forward because they're not doing anything. Every time this law firm, and I don't care if it's Mr. Ferrone or Mr. Harris or Mr. Smith or whoever shows up, that firm is responsible for following the orders of the court, just like everybody in my office is responsible for following the orders. Whether I'm in court or not, whoever is here from my office is responsible for following the same orders that they are. That firm has thumbed their nose at this court, the defendant has thumbed their nose at this court. At no point have they attempted to comply until sometimes the night before a hearing, we'll get some version of some records that don't meet the full subpoena. We come in the next day and there was confusion. We thought it was resolved. There's a password. I have some of the same doctors as Ms. Hornbacher. I go to Shore Hospital too. The password is in the possession of the patient to access the patient portal. If she doesn't know her own password, I'm not sure how to help her, Judge. But here we sit. My client is thousands of dollars in. We are 3 hearings in. We are 2 subpoenas in. We are in order to compel in, and we had our second hearing for a show cause. And to this date, Ms. Hornbacher has done nothing to comply, nothing to follow the rules, nothing to say that she's complying with the spirit of the law, nothing at all. Yesterday, I got a call from their office saying that my client contacted them saying we didn't have a hearing today, that we were having mediation. My client has never had contact with their office. Then when I confronted their office about it, it was, oh, your client didn't do it. We were confused. Our client said, your client said, we don't have a hearing tomorrow. This is the game that the defendant continues to play. And the only person that is being disadvantaged is my client. We're here again. This case could have been resolved, Judge. For the court's record, we are 316 days, 10 months and 12 days of no compliance from the defendant. There has to come a point where the defendant is held to the same standard and her attorneys are held to the same standard as the rest of us. If I had walked in here for almost a year and said, Judge, I don't care what your rules are, I know exactly where I would be. Exactly where I would be. Our request is that she be held in contempt, she be ordered incarcerated until full compliance with subpoenas be issued, that all fees and costs for the June 7th hearing, which was submitted by affidavit, the July 26th hearing, and the 10/16 hearing be awarded to my client within 7 days of today's date. That she be barred from any further discovery, that the default remain in place. My client is prepared to enter a judgment. The friend of the court has signed off on the judgment we've prepared, Judge. That both parties be immediately drug and alcohol tested today. That if the court does set aside the default, the trial be adjourned because there's no way for us to prepare without all of this documentation. I don't know how else to convey to the court that this defendant doesn't follow the rules. Perhaps another understanding, the court will remember we just entered the custody order. They withdrew their objection and the custody order was entered. I can tell you there's another motion coming, Judge. Mom is in violation of number 10, number 33, number 34, and number 35 of that order already. Leaving this courtroom that day, she called and threatened to remove the child from her typical school schedule because she didn't like it, because the father wasn't having parenting time. She's ignoring the direction of the child's therapist. She has still failed, and I believe Mr. Holdup will attest to this, to provide her psychological that she was ordered to immediately turn over to the front of the court. And by her own medical records, she has discontinued counseling, which she was ordered to continue and provide all of those records to the front of the court. And none of that has ever occurred. And I don't say this for the court to penalize her on that order. That's not before the court today. I say this for information and for the purposes of the court understanding. The defendant has no desire and no willingness, and at this point has shown zero ability or desire to follow the rules of this court. We want it resolved, Judge. We brought a prepared judgment to go over with them. I told Mr. Harris yesterday, come early, come at 8 o'clock. Judge is great about it. He will let us sit and work through this. Let's go through it. I'll let you know if we're interested. And here we are by Zoom again. No interest in resolving it. So I appreciate what Mr. Harris says, but what he's saying to you and what he's doing and what his client are doing are very different. So we would ask that she be held in contempt and all the requests that I made be honored. Thank you, Judge.
Repeat your prayer for relief.
Oh, yes.
Start.
Woo! Yeah, it takes a lot for an attorney to get this upset. She is over mom and mom's attorney. What do you think the judge is going to do? I don't think the judge is too happy either. I mean, I do know how this ends, but what do you guys think? Well, she just listed off a bunch of things. What do you think the judge is going to do? While I'm paused right now, pause your video. Let me know before this plays out. Let me know. All right, let's finish this one up. There's only, 3 or 4 minutes left of this hearing.
Starting with being, you're asking that defendant be held in contempt.
Yes, Judge, that she be held in contempt and that she be jailed until full compliance with both subpoenas. That all costs associated with the 6/27/24 hearing, which have been submitted to the court by affidavit, be awarded. That all costs for the 7/26/24 hearing and all costs for the 10/16/24 hearing be ordered. That she be barred from any further discovery. That a default judgment does enter on the plaintiff's behalf. That if the default is set aside, that the court allows to adjourn the trial because we don't even have the documents to prepare yet. I might add, the defendant has never filed not only an answer, but never filed a VFI, Judge. We have no way to verify under oath what her assets and debts are. Zero. And again, we're 316 days into this. That there be an immediate drug and alcohol test for both parties. And that's it, Judge.
Mr. Harris.
Okay, well, as far as he says, well, what I asked her, was there a mediation today? My client did believe that there was a mediation today, and I asked opposing counsel, was there a mediation? I said no. I knew there was a court date today. Now, as far as going back, I think it's only fair that, I will stipulate that she be awarded costs. because, I guess things were not done that should have been done. That would be only fair, but I would ask Judge that my client not get jail time because this is not completely 100% her fault. I hate to throw previous counsel up under the bus and the mistake of today, but that's not 100% her fault. So I don't believe that it would be fair that she be jailed. However, as far as costs for their time, based on the truth of what she was saying, I think that's only fair that, that they are rewarded costs for these hearings and when things were not done in a timely fashion.
Thank you.
Yeah, that was kind of a half-assed defense right there. I mean, he addressed the things that he had to, but get a little bit more passion to it. You saw how angry the other attorney was. Got to match it, right? No, you don't, but still. All right, I'm letting it play out. If you haven't done it already, hit that like button. Let's go, Judge. Get her.
Frankly, I've heard enough. And the confusion or lack thereof may be relative to appearing in person. Maybe counsel wasn't there, but client was there. This court is going to order as follows. First, all costs relative to June 27th, July 26th, October 16th, ordered against the defendant. Plaintiff's counsel to submit all the costs, and I'm ordering costs in this case. I'm closing discovery relative to the defendant in this case. The default judgment enters in this case. I'm ordering drug and alcohol testing today. I mean, the reason the court is doing this, and the court has been extremely patient, and I'm not pointing fingers at, well, previous counsel or this counsel or that counsel. No, it's the same standards apply to the law firm as an individual attorney. It doesn't make a bit of difference. I'm holding the defendant in contempt as well. I'm going to order that she serves 2 days in the county jail, no days credit. After her test today, she is to report to the jail and she can be released. Let's see, it would be this coming Friday at 9 a.m. I'm not playing games anymore. That's it. I'm just not playing games. Submit an order, counsel.
Thank you, Judge. I will.
That will conclude the proceedings.